Here's a story for all of you. For a time 20 years ago, this was the year 1999, millions of people across the world, this included corporate chiefs and government leaders, they feared that as soon as the clock struck midnight, the internet would come crashing down and bring down most of the civilization with it. Why this fear? Because when computer programs were written, and this was early 1960s, they were written in a way that 4-digit years were abbreviated. So computers were trained to read, say, 1998 as 98, just as 2 digits to save memory space, because it was much costlier back then. So what they feared was that when the year 2000 came, the computers might not read double zeros as the year 2000. They might just read it as 1900, might not actually notice what year it was and come crashing down. But when the clock actually struck midnight on 1st January 2000 and time zones after time zones saw the new year, nothing actually really happened. What did happen in the year 2000 was that India got the Information Technology Act to keep up with the paradigm shift in the IT industry, in the information technology sector. And right now this act rules essentially every facet of our online lives, and this is why this act is extremely important, and we'll be discussing it in today's episode of Laws of the Land. For this episode, you have me, Apoorva Mandhani, we have with us Bhadra, Sinha, and we have with us Mr. Akash Karmakar, who is a tech lawyer and a partner with the law firm Panag Babu. Thank you so much for joining us today, Akash.
Thank you for inviting me to your show.
Thank you so much, Akash. So Apoorva has given a brief background to the IT Act, but to start with, we would like to know the objective behind the IT Act. What was, at that point of time, why was the need felt to have a new law dealing with different crimes, taking place in the cyber?
So honestly, Bhadra, the law was not reactive to a need. It was not a law which was promulgated as a response to a lacuna in the law. We had a convention which was passed by the United Nations General Assembly, and thereafter the United Nations Committee on Trade Law issued a model law on electronic commerce. The IT Act is essentially modeled after that particular law, and you'll notice that the first iteration of the law, which was passed in the year 2000, has many facets of the model law, which has actually transgressed into the Indian IT Act, which perhaps is like trying to fit a square cog in a round hole. Because I think at that point in time, India was not ready for the law, simply because India was trailing behind the Western countries, and the law assumed certain things as being given. In India, we weren't there just yet.
Okay, but this law introduced certain, new areas of crime, in the sense, although we had the IPC to deal, with criminal acts, but they were all offline. So I think that is what everybody sees IT Act as, that, it introduced certain new crimes, particularly the ones that were taking place, the cyberspace. So can you just explain to us what exactly was the model of the IT Act when it came to dealing with the cyber crimes?
Absolutely. So in the year 2000, when the IT Act was initially promulgated, you'll notice that the IT Act essentially had broadly 4 segments. One which dealt with how it recognized digital signatures, and it recognized certain segments of information as being evidence. So you'll notice that the initial iteration of the IT Act, it amended the Bankers Book Evidence Act, it amended the Indian Evidence Act, and yes, it is read with the Indian Penal Code, but it's intended in that sense to fill in certain lacunae, which the initial iteration did not actually fill. Because as I said, the initial iteration was reactive to international convention rather than being law that we wanted to promulgate and had our legislation think about how to adapt that and homologate it to the Indian context. So what ended up happening is that the second iteration of the IT Act, which is the amendment brought in the year 2008, which was actually the law which dealt with several of these offenses. And you'll notice that the law which was essentially drafted in the year 2008 was reactive to several instances of cyber crime, cyber terrorism, and that brought in the segments that dealt with cyber stalking, harassment, bullying. I would say that it was a little overly broad when the law was introduced, and I think everyone knows how Section 66A, which deals with online instances of harassment and sending people offensive messages, it was used and abused by its implementation overly broadly. So you have several instances where you have an FIR registered against someone for merely doing something which would be expressing an opinion. So to answer that question, I think the Indian Penal Code had a framework that was already in place, but there were certain crimes which were crimes which could not have existed without the internet. Crimes such as cyber stalking, cyberbullying, threats made over the internet, the introduction of malicious software or malicious code into a computer system, theft, which is not in the traditional sense, but theft of digital assets, digital products, things like that, which essentially was introduced by virtue of the IT Act. And whilst the initial law in the year 2000 had thematically conceptualized that these would be offences, we see that it's actually in the year 2008 when the IT Act was amended that there were several provisions which were brought in to criminalize these offences, which, if you are to read it alongside the IPC, fill several lacunae where the IPC, because it's an archaic law, it, let alone predicting what would happen in the year 2000, it essentially didn't predict several crimes starting in the 1900s. And therefore, it brought into the digital age a set of laws which were incredibly archaic, but it was not intended to be an overarching legislation read by itself. And therefore, you see, by virtue of several subordinate pieces of legislation, it's tried to fill several gaps. What that's left us with is a bit of a patchwork orange, because we see that there is a broad framework and there are several laws which have been promulgated under that particular parent legislation. But there are several gaps even within that framework.
So basically what you are saying is that the law which was brought in 2000 was not sufficient enough to deal, with the changes, with the wave of cybercrime offences that took place, that started taking place from there onwards. And it is only that in 2008, these new offences were introduced through the IT Act. And these were basically supplementing the IPC. Is that so?
That's right. And in the year 2008, there were a host of other amendments which were brought in to modernize the IT Act, because in its initial form.
So between 2000 and 2008, what did we really witness, that actually led the government to bring in these changes? You speak about certain offences that were introduced, and you also say that more changes were brought into the IT Act. If you could just briefly explain about those changes and what exactly happened during those 8 years that prompted the government to, make these amendments.
Absolutely. I think from the year 2000 to 2008, India was struggling with trying to use archaic laws with modern concepts. And whilst law does play catch up to technology, what we noticed during that specific era, if you will, over those 8 years, we started seeing that there are intermediaries, for example, which were being held liable for content which was posted on it. The year 2000, I would say the year 1995 to 2005 were the early years of internet adoption in India. We saw India have a permeation of mobile handsets into the last mile. And that really brought the internet into villages, into towns in India. What we also saw with that is websites which were essentially e-commerce websites being held liable for content, comments, products which could have been viewed as being offensive, or say, for example, there were illicit goods, narcotics, which were being sold on an e-commerce platform. And today we appreciate the difference between a marketplace and an inventory-based e-commerce platform which supplies its own inventory versus a marketplace which acts as an intermediary. But this concept of what is an intermediary was missing between the year 2000 and 2008, and that was one key amendment brought in. They also realized that there was no central nodal regulator for cyber crime. And that was brought in the year 2008 by virtue of the Central Computer Emergency Response Team. And the CERTIN, as we call it, was finally set up in the year 2011 with the certain rules coming in 2013. So it's honestly been a very long process for the law to actually come about, and then have the law set up a specific sectoral regulator or a sectoral oversight authority.
Okay, so which means that between 2000 and 2008, probably the usage of internet increased drastically, maybe, and that also means that crimes committed by individuals may have also increased during that period, and that could be the reason why, you know, these intermediaries were getting entangled in litigation, because we witnessed the Bazi.com case as well. So was there some sort of an this is just a question, was there some sort of an industry pressure on the government, or it was probably these amendments were brought in after much thought? What exactly would that
so I don't think there was industry pressure. There was a need which came about because imagine you're an intermediary today. What is the concept of an intermediary? An intermediary is essentially supposed to be a conduit between two separate parties. Right. Now let's apply that concept to WhatsApp, where there are two people who are using a messaging platform to communicate. Let's use that concept in the e-commerce space, where you have a marketplace, you have sellers listing their goods, you've got buyers who are buying them from the e-commerce marketplace. But the marketplace merely facilitates the meeting of two or more people. Let's apply that to social media, where you have multiple people interacting over a platform, which merely provides a technology-based conduit to communicate. Should that platform logically be held liable for what people are using that platform for?
So how did the law answer that question?
That's precisely what the 2008 amendment brought in, essentially saying that an intermediary, if not amending, modifying or altering the information that passes through it, should not be held liable for the content that it hosts. Right. However, this broad...
means there cannot be any criminal prosecution, or even it exempted them from some sort of civil liability also.
It protects the intermediary from both civil and criminal liability for any third-party content that it hosts. Okay. But there is a proviso to this which is known as the safe harbor. And every safe harbor must have certain checks and measures. So the proviso is to say that an intermediary must comply with certain due diligence measures, such as ensuring that it has terms and conditions which puts to notice its users about what end users are permitted and what end users are not. The second part of this is essentially that the intermediary must not be altering the information in any way. Okay. So there was a broad series of diligence measures that were introduced by certain rules which effectively dealt with what intermediaries could or could not do to avail of the safe harbor. That was introduced in the year 2011 and then further amended in 2013 and then overhauled in the year 2021 with the intermediary guidelines and digital media ethics rules.
But those rules are extremely controversial, right? They've been challenged across the country in various high courts. Could you tell our viewers a bit about those rules and why they're so controversial? Is there a sort of tug of war that's going on between the intermediaries and the government as to the sort of protection that they should be getting?
Absolutely. So I think Bhadra asked initially whether there was an industry push towards instituting safe harbor. Yeah. And to that, I think the answer is a clear no. Because logically speaking, an intermediary must be defended from third-party liability. We had also predicated that safe harbor against certain diligence measures, as I mentioned, but those diligence measures have gotten increasingly tighter over the years. With the introduction of the rules in 2021, we have several loopholes where the rules prescribe for diligence measures which almost makes an intermediary police its own platform. Okay. That puts the intermediary in a very precarious place because there is a limit to how much interference an intermediary can have, how much control an intermediary can have over the content on its platform to be able to actually call itself an intermediary. Okay. On the other hand, the law prescribes certain diligence measures which does not allow the intermediary to actually take that laissez-faire approach. Okay. There is also a question of what is the final determinant of a crime. What are the code of ethics which an intermediary must follow, because the law has relegated unto the intermediary the task of assessing what is content that should be blocked, what is content that should not be blocked. And that leaves in the grey the determination of what content must be, so to speak, self-censored by the intermediary.
But
okay, you carry on.
Okay, but that I feel that brings us to the next discussion on taking down of content, which is quite the provision 69, section 69A is again a very controversial provision within the law. Could you, for our viewers, explain how content is actually taken down as per the law? What does the law provide for?
To answer your question is that the government will issue a order, either an interim order or a final order. That order gets reviewed by a committee comprising of members from the Ministry of Home Affairs, the Ministry of Electronics and Information Technology, and certain other ministries, which but the composition changes from time to time. But having said that, this particular committee, which is a review committee, reviews each of those orders and may sometimes grant a personal hearing to the person who has been blocked from publishing certain content. As of right now, what we've seen is that the review committee has rarely ever rescinded an interim order. So interim orders typically tend to be fairly long lasting, even though that was not the intent with the blocking of Chinese apps in the year 2020 or with the blocking of porn sites earlier over the last decade. These interim orders have essentially started becoming permanent orders. And there have been fewer instances where a committee has actually called for a person.
And are these decisions by the review committee, can these decisions be challenged before the court?
That's right.
By the intermediaries or by the hosting websites? For
the decisions essentially of the review committee, as you rightly pointed out, can only be challenged before a court of law. There is no intermediate appellate mechanism. But more often than not, where we have seen blocking actions based on issues concerning national security, there is no point of challenging that in a court of law, simply because courts have traditionally stayed away from matters involving national security.
Okay, what if the content, if taking down content is, affecting some third party, in the sense, if it is a content written by me which is taken down on the orders of the government, of course, under this particular section, does the law provide any, in the sense, can I, under the law, challenge this review committee decision? Is it possible? Is that possible? Or it is only the host or the intermediary who can do that?
So at present, if you have published certain content, but you've not published it on your own website, you've published it on a third-party website or on a social media platform which is an intermediary, it's only the intermediary which can challenge the takedown. Because the directions are against the intermediary. So if you've published content which is defamatory, libellous, or it's directed to incite feelings of violence or hatred, you wouldn't have the right to be able to go ahead and challenge that specific order unless you have a writ petition which is filed where you're challenging your right to your freedom of expression and speech, whereby you say that the taking down of certain content which you have published impinges on your rights, which is a very different action than a remedy directly against the takedown order.
So, but can I take action against the platform, or even that is not permitted?
More recently, with the 2021 intermediary regulations coming in, there has been the introduction of a grievance appellate committee. That grievance appellate committee allows you as an aggrieved user to either complain against content which either operates against you, which is defamatory and libellous and hurts your public image, or any content which has been taken down unilaterally by, say for example, an intermediary, not necessarily where a government order has directed the intermediary, but primarily against unilateral and arbitrary actions of the intermediary, which is then put forth before a government appellate committee. So as I said earlier, there seems to be a lot of discretion which has been relegated to intermediaries to take down content.
Okay, so my cause of action will arise if only there is a unilateral decision by the intermediary.
That's right.
But if the takedown notice or the takedown orders are given by the government, then I will not have any say in that, right?
Not with the government, not with the grievance.
That's what I'm saying. Then I don't have an option.
You have to then have a separate remedy by virtue of a writ petition.
Writ petition, that's the only remedy.
Constitutional courts to say that your freedom of expression has been impinged.
Yeah. So talking about freedom of expression, we had a very controversial clause in the IT Act which was taken down by the Supreme Court, Section 66A. Can you just explain, what exactly that section was about, and why was it challenged, and what was the final judgment by the Supreme Court? Because it was very hotly contested in the Supreme Court. The government was defending it, but there was a batch of petitions which actually contested it. But despite the fact the Supreme Court has taken it off, some prosecutions continue to happen under 66A. We recently saw that also. So if you could just give a overview of the section.
Absolutely. So 66A did not exist in the initial version of the IT Act which was promulgated. 66A was brought in the year 2008 And it finally got struck down in 2015 with Shreya Singhal versus Union of India being a landmark judgment where the Supreme Court actually intervened and said and issued directives thereafter to sensitize police officers, senior members of the IAS and IPS to ensure that no actions were taken basis Section 66A. What was Section 66A? Essentially, 66A was introduced to prevent harassment, to prevent offensive content being posted. That in its very definition is incredibly broad. And where the law is broad, obviously there lies tremendous scope for abuse, with that discretion being given to any other authority to actually interpret the law. So Section 66A was being viewed as an omnibus right, where the police was using that in several FIRs against people for posting content that would be considered offensive, with the definition of offensive being incredibly perspective based. So just to give you some context on Shreya Singhal versus Union of India, in 2012 there was a bandh in Mumbai. There were two college-going children who had protested against that bandh and written certain articles on Facebook and had posted certain content on Facebook protesting the fact that there was a bandh declared in Mumbai, causing disruption to our financial capital. Another girl had merely liked that post. And if you recall, in 2012, there were Facebook posts which were posted by several people, and people went about liking it without necessarily commenting on the post, without retweets being endorsements, without the concept of retweets being endorsements having kind of trickled into the public domain, as we see with Twitter today. So in the year 2012, when the police went ahead and arrested these two college-going children, there was the question raised as to whether anything which was considered or could be construed as being offensive, should that be capable of A, being taken down, and B, being the cause of action, why criminal prosecution should be initiated against you.
Yeah. Okay.
Excuse me.
Okay, so and then I think while striking it down, the Supreme Court commented that this section violates the freedom of speech and expression, which is kind of, given to us by the Constitution. But while you were explaining Section 66A to me, it just struck me. So we have 69A now, okay? Do you think that the government has in some manner circumvented the 66A judgment? Because 66A spoke about criminal prosecution. Over here, the government can actually issue takedown orders in case they find the content objectionable. And do you think that this is also very widely worded?
Absolutely. Section 69A, which essentially allows for blocking actions to be taken by the government, is incredibly broadly worded. So we have seen actions by the government in as recently as 2020, where 211 apps were banned. Those apps were banned purely on the basis of the government having a suspicion regarding the app surreptitiously collecting user information. We see the very same argument playing out in the United States of America today, with TikTok deposing before Congress. The fact of the matter is, unless we are able to have a law that prescribes that there is a data audit, unless the law is able to preempt issues that come out of technology, it will always play catch up to technology. So the procedural rules for calling for evidence, the procedural rules that would guide an authority on what evidence it must take into consideration when it is assessing guilt for an app company which is collecting data from India, is incredibly vague. The law right now is designed in a manner in which the government can take down anything ranging from obscene content to content that operates against political interests. And we've seen how with the ebb and flow of various governments, it's been used and abused over the last 20 years. And we're seeing a broadening of the scope of Section 69A as the years go by, to essentially be used to target not just what it was initially intended for, which is essentially where you have content that would be harmful for the Indian public, but content which the government merely does not like.
Okay, I have another question on a recent controversy that came up in the Supreme Court. It actually first came up in the Madras High Court related to the IT rules, which talks about traceability of the originator, especially on a platform like WhatsApp, where you have encrypted messages. So of course that issue is still pending in the Supreme Court. But can you just speak a little bit about the controversy, because I think the government has been trying to introduce this through the rules, but there is a lot of opposition to it. Why is it so? If you could just explain.
I think that's an exceptionally good question with respect to the rules from 2021, because what you've essentially pointed out by virtue of your question is precisely the contradiction in the law. The law intends for intermediaries to continue to remain intermediaries, to continue to remain a platform and a conduit where you have third-party information that it hosts. It is prescribing that the intermediary should not take any steps to alter the content on its own platform, which is exactly the moot point in the Bazi.com case which you had mentioned earlier, where Bazi.com was not actually altering certain data. With Facebook, with MySpace, we have seen several instances where the platforms have not been held liable simply because they don't alter the data which is on the platform. They don't take it down, they don't alter it in a manner that would be prejudicial for a certain segment of users, they don't alter that data in a discriminatory manner. By the law casting upon the intermediary an obligation to decrypt data, what you're doing is you're opening a Pandora's box for abuse. Currently what's happening is, with messaging services such as WhatsApp, you have what's known as end-to-end encryption. Now you have what's known as an encryption standard, where you have AES 128 or 256 bits of encryption, which determines the degree of encryption. That ensures that the data which is passed from your phone to my phone is scrambled so that it cannot be intercepted. One must obviously be open to the fact that the government is faced with ever-increasing national security challenges. And being cognizant of those national security challenges, the government needs to ensure that it has different ways of being able to intercept data. Anti-national and terrorist elements have been using WhatsApp as a mode of communication, and therefore, whilst well-intentioned, what you're essentially doing is you're asphyxiating the ability for an intermediary to truly operate in a laissez-faire manner. You're telling them that you may have to decrypt data which is initially encrypted end-to-end. That compromises the entire security of the system, simply because if a government authority can access that particular data, what is to say tomorrow if the entity which has the power of decryption is compromised, that you don't have a data breach? Because opening that window for decryption, opening the ability to intercept, is not necessarily just for the government, it's also for any third party to be able to do that without necessarily following the due process of law that the government envisages.
So my next question is, around the controversy surrounding the new IT rules. We know that certain sections have been challenged in various courts, particularly the ones related to the online media. So if you could just, briefly explain about it and what exactly are the challenges.
Whilst there are several challenges with the implementation of the Intermediary Guidelines and Digital Media Ethic Code rules of 2021, some of those essentially relate to fact-checking and the manner in which certain media houses would need to fact-check data. The same also applies to how social media intermediaries would be deprived of their safe harbor unless they undertake certain due diligence measures. Now, those due diligence measures, as I had mentioned, are incredibly prescriptive, and it follows a one-size-fits-all approach. So, should those diligence measures not be implementable in every circumstance? Should certain data slip through the cracks? You're still casting liability upon an intermediary, which is a significant move from what we were looking at in 2008. So, when the needle moves and when we are garlanding someone with responsibility, you cannot garland them with liability for not discharging obligations that hitherto did not exist. And then that is the broader question of how does that tie into the ease of doing business in India?
Right, that makes sense. And you've, I know, for a while now mentioned that the law has been trying to play catch up ever since it was brought in 2000, catch up with technology, catch up with the new sort of crimes that were coming in the cyberspace. Do you think it is done playing catch up? Do you think it needs more amendments to be brought in, or do you think it's time for a complete overhaul?
And my one add-on question is, do we need a specialized agency to deal with crimes covered under the IT Act, or to deal with these kind of instances which we are coming across with regard to a lot of anti-national activities happening online? Because so far it's only the local police which is handling these kind of cases. So of course, as Apoorva said, whether there is a need for an overall, or how do we manage it, and do we really need a specialized agency to specifically deal with IT Act offences?
So I think the answer to that question is a two-part answer. One, we do need an overhaul, and the IT Act, as I mentioned, has resulted in a patchwork of subordinate legislations which don't read very well together. What ends up happening more often than not with something like the IT Act is that you're relegating to the rules the meat and substance of the IT Act. We're seeing that perhaps even with the latest iteration of the Digital Personal Data Act. Now, when you're doing that, the rules must be harmonized. The Digital India Act, which is currently on the anvil, and as Rajiv Chandrasekhar has rightly said, we need to take a cold hard look at whether the IT Act requires reform now, with the lens of a legislation that does not prescribe for the past but preempts the future. The second part of that is essentially that we need to have a regulator which is harmonized. The Cyber Appellate Tribunal, for want of qualified members to actually staff the Cyber Appellate Tribunal, as well as for a want of matters which go to the Cyber Appellate Tribunal, was finally abolished. And that shows how providing for multiple regulators with overlapping areas of regulatory purview and jurisdiction results in certain regulators becoming redundant. So having a nodal regulator both with the Digital India Act and perhaps even the Digital Personal Data Protection Act would certainly be the way to go going forward.
Right. With that, on that note, we've reached the end of this episode. We spoke about how the law was brought in the year 2000, but as per Akash, the law has been sort of playing catch up with technology, but perhaps it's now time that the law preempts whatever's to come in the future, and that, according to him, would form a legislation that could be enforced in a better manner than what we have right now, with all its rules and with all the other laws sort of coming together to form a patchwork of legislation. Thank you so much for joining us for this episode, Akash, and for all our viewers, thank you so much for watching this. As I always tell you, do let us know in the comment section if you want us to take up any law that you're interested in, and if you want us to get any expert that you would want to listen to, and we're always happy to take your comments and suggestions up. Thank you so much for joining us.